another week in Trump's America and another episode of the Constitution and American Life with the Friends of Publius. Well, it is post-midterm election America, and to many, democracy is still alive and well, if not being observed in the ICU. Contrary to many polls and pundits, there was no red wave, and the Democrats were able to hold on to control of the Senate. I think the only thing we can count on for the next 2 years is that gridlock will continue to dominate the political discussion, and the Supreme Court will have more influence than any other of the political branches of government. Tonight, we are very honored to be joined by the CEO of the Center for Civic Education, Christopher Rayano, who is also, if I understand correctly, a law professor at Columbia, a practicing attorney for much of his young life. And so, Christopher, we welcome you here to the Friends of Publius and look forward to our discussion.
That's wonderful.
As you all know, the We the People program is the love child of the Center for Civic Education and is entering its 36th year as the premier civic education program in the United States. Quite a feat, given that it was originally slated to be a 5-year program to celebrate the Constitution, the bicentennial of the Constitution and the Bill of Rights. When this program first started, I was a young, slender, blonde-haired teacher of 4 years looking for a program to liven up my government courses. Now I am an old, fat retiree just trying to stay alive. Tonight, we are going to be discussing a somewhat ignored and misunderstood element of the Constitution, the privileges and immunity clauses found in both the Constitution and the 14th Amendment. Along with that, we hope to touch on state citizenship and the issue of immigrant rights. So let's get right to it and begin with our illustrious professor of history from the University of Wisconsin-Madison, and that would be Professor Tim Moore. Tim, in order to provide a consistent foundation of understanding, can you explain what is meant? Yeah, I know. What it's meant by privileges and immunities of citizenship. And then a second part to that is, was this clause, which is found originally found in Article 4, Section 2 of the Constitution, was this at all related to the powers and the design of the Articles of Confederation? Professor Moore.
Well, it seems like all the founding period documents up to the Articles, and actually including the Articles too, whenever this phrase privilege and immunities pops up, like I looked at the Connecticut Constitution, I think, let me see, Connecticut, North Carolina, Vermont, and others, whenever there's this phrase privileges and immunities, it's always connected to a discussion about citizenship. And there's always this notion that it's related to property. There's a heavy commercial emphasis on how that phrase is used in the context of citizenship and property. And a lot of it has to do with, is property, can you move it around? Can you own it in one place? If you own it in one place, do those rights of property ownership apply in another place? So in those first constitutions written right in the middle of the American Revolution, frankly, there's always a discussion about who's a citizen, and then if they're a citizen in state A, do they have the same or similar rights of property in state B? So that's the context of those early state constitutions. Now, the second part of your question, I'm not sure I quite understand it. Could you rephrase it? I'm going to do a We the People student thing. Could you rephrase the question, sir? If you're there. I guess he's not.
Well, Tim, let me ask you a question as a follow-up.
Sure. Yeah.
In my reading here, they're trying to actually do some preparation for this evening. Would you agree that when because you can find privileges or immunities, that actual terminology in so many older colonial documents, you can find those in Old English documents. Would you say that that's synonymous with rights or liberties?
I think in part it is. I mean, and we've talked about this before, that the British colonials are very sensitive about the right of migration, and does it impact any of their status or rights if they move outside England? And that gets to the issue of, do they see themselves in the realm, or are they outside the realm? So the transportability, I get, that's not a word they used. They often use the word emigration. So do things move with me if I physically move from one place to another? That's a key colonial sensitivity. And in their minds, it is those rights of Englishmen. But when it comes to privilege and immunities in the early state constitution, there's always a heavy connection to citizenship in that state that they're in, and also the issue of property. Can it, our property, and think about this, after the revolution, there's a lot of property that's in question. If you were a British loyalist. So there's a lot of property cases that are floating around during the revolution as well as after the revolution. So the connection of privileges has a lot to do with property and financial transactions. Now,
Well,
David, I didn't quite catch your second question.
Well, again, I'm wondering to what extent the Article 4, Section 2 Privileges and Immunities Clause was directly related to the Articles of Confederation. That is, was there
shorter.
So there was a privilege. There was a privileges and immunities in the Articles.
Yes.
And so this is just a movement. You know, this is not a new creation. This is just moving it from one constitution to the next.
Well, in the Articles, it says free inhabitants. In the Constitution, it says citizen. So there's a textual difference. And I think, and certainly in the 14th Amendment, it has to be so, because citizenship is defined in the first part of the 14th Amendment. So there's a textual difference, and in the Constitution's, it's shorter. Now, I don't know exactly, I mean, there's several things you can conclude from that if it's a shorter statement about privileges and immunities, because the Articles, there's a whole paragraph. And again, in the Articles, there's a heavy dose of financial connected with that privilege and immunity statement.
Professor Kavanaugh, because you brought it up, and I know you're still, in the classroom, I would get kids bring up this notion that because you just asked about privileges and immunities being related to rights. Is there a difference between a privilege and a right?
I don't think so. I don't think so. I see Tim rocking back and forth here, so maybe I'll
not just me.
Well, but I was, and again, actually doing some preparation for our program this evening.
And I why you keep saying that. I can't figure that out.
Well, maybe I don't prepare as much as I should sometimes, but and you guys are going to be shocked that my buddy Clarence Thomas, and so I was reading one of his opinions, and I agreed with him a lot in his opinion, and he's going to make this point that there's a comparison between privileges or immunities as well as rights or liberties, and he's going to talk about the synonymous use of these terms back and forth in documents pre-revolution, colonial documents, English documents, and the idea. But I think Tim's point is well made. You see a lot of that tied to citizenship and property rights. Those property rights, that property opens these doors for you for certain privileges or immunities or liberties or rights.
Okay, Professor Moore or Christopher, I saw a little reaction to that, but Professor Moore, you kind of really went back. Here's my kids. My kids say like a driver's license isn't a right. It's a privilege. So that's what leads me to ask, is there a difference between a privilege and a right?
I think something that I'm coming back to that Tim mentioned, and Chris, you were mentioning this too, when it comes to thinking about, this and where this comes from. There's no question that we have to tie the privileges and immunities clause to the moment of the day, right? We see this in the Articles of Confederation. We see that, if I remember correctly, it's even in the context of discussing how vagabonds don't have
Right, yeah.
privileges and immunities, right? So, wow, that's my useless knowledge for the day. But I think we have to be really, really careful tying that to the privileges or immunities clause that we see later. And we'll talk about that, I think, in the bigger context, because I think we have to always think about constitutionalism as the evolution of how we're thinking about where we are in the moment and how that really is baked into both the language that's written and, of course, always the unwritten text that comes along with thinking through constitutional theory. And so I think in some ways, it's a great example, right? A driver's license is a privilege, not a right. Okay, we can think through that, right? And we can go down the understanding of how states license folks to do all sorts of things that are privileges and not rights. But I think the words here have a little bit of a different meaning, right? And when we think about where we were at the point of the Articles of Confederation and where this has evolved, privileges and immunities, I come back to the word often about and frequently think about the word of comedy, right? And not with an E, but I-T-Y, and how there was so much real contention at this time in our national identity when it comes to thinking about how did we treat people of different states, either similarly or differently? How did we ensure that there was a common law equality when it comes to thinking about processes and procedures between the states? That was a huge issue, because if you remember, one of the reasons that the Articles failed is the failure of states to act in unison on some really big, important topics. Tim, I love how you bring up property. You have to always be conscious of the central role that property plays in the American ethos. It's life, liberty, and property. That's our big trifecta that we find in the 5th and the 14th, right? And so I think in so many ways, you cannot divorce, and what a good word to use when it comes to comedy, you cannot divorce the reality of how the Articles, and what was it, Federalist 42, oh gosh, and another like Federalist 80 or something that talk about why this is important, how this is in many ways the basis of our union, how this actually is really critical if we're going to move from this very decentralized Confederate model to this much more centralized federalized model, where there does need to be some equality and comedy between the states and how people are treated between those states. And thinking about how that's evolved over the years to the or as opposed to the and in the 4th article, I think is a fascinating constitutional journey.
But in the larger context, I would have students really look at all of Article 4, because almost the entire thing is about interstate cooperation. And I'm looking at, when I look at Article 4, there isn't a ton of rights per se. There's not a lot of rights language straight up at face. It's a lot of procedure and cooperation issues in Article 4. So I would really urge students to not pull this out from its context of that section of the Constitution itself, interstate cooperation.
Mike?
Yeah, I have a comment, but it's based on just listening to what you've said so far. It seems to me that Article 4, Section 2 it's not saying the government can't do something like we see in so much of like our rights talk. It's like it's just that it's there, right? They shall be entitled to all, which is just like, okay, so I don't know where these things come from, but it seems to be like they just exist and you're entitled to all. Versus in the 14th Amendment, it seems like after those 70 years of experience and being like, man, Madison was right, these states are getting away with stuff. Let's stop the states, right? From passing laws that shall abridge, not all, right? The word all is left out, but it's the privileges, and as Christopher says, or immunities. So I think there's some like, I don't know, some learning going on. When you compare those two sections, it seems like they're similar enough, but then they're different enough based on historical context. I'm really persuaded by what Tim and Christopher said about the context of Article 4 and thinking more about commerce and property. And I think the context of the 14th Amendment is more about rights and about what states have done in the previous 70 years of not respecting the rights of all people. So I don't know.
Well,
I don't know I'm getting there.
let's explore that a little bit deeper. Professor Riano, and I need some clarification, and you've already figured it out. I'm the least learned member of this panel here. I went to State University in California, where all these other guys, highfalutin colleges. So help me clarify something. As we just talked about, we've got an Article 4, Section 2, privileges and immunities. So why do we need, after the Civil War, another privileges and immunities clause in the 14th Amendment? Because, well, anyway, run with that. Why do we need a second one?
I will say this, I always come back in some ways because I do think text matters. And I think it's absolutely telling to go from an and to an or. I do not think that that's a mistake. And I think you have to think about the times that these things are written in to understand why we go from an and to an or. And I think as you think through where we are in the juncture of our national history, each of these times, at the time that you're thinking about the privileges and immunities clause, that relationship between the states is really critical because you have the failure of the articles. So at the front of everyone's mind is, well, that didn't work very well. How do we fix it? And how do we fix it in a way that matches the moment? I don't actually think that's too different than after the Civil War. I actually think it's just what's the moment that we're meeting at that point. And we're meeting a very different moment. In one instance, we're meeting a moment of absolutely fundamental, how do we set this structure up? Because that didn't work very well. And we're still a very nascent nation at that point. After the Civil War, we're setting things up where we're thinking about, well, we did give the states a lot of opportunity to try to figure this out, and they didn't do such a great job there. So how do we ensure that there's a national federalization of certain fundamentals? And how do we start to think through that when it comes to writing what is easily one of the most important amendments to the US Constitution? And what's so fascinating looking back at it now, and this goes to your comment, Chris, is you could just as easily have put our constitutional hats when it comes to thinking about rights, liberties, and responsibilities right here, as we've done instead when it comes to thinking about substantive due process and creating that regimen that we've created over the years between that and the equal protection world. And so what I've always found so fascinating about this part of the 14th Amendment is the way, and I think it's really important to think about how we were thinking about things at the time. I think it was an Ohio congressman that was really focused on making sure that this text made it into the actual amendment, right? We borrow a lot of our 14th Amendment jurisprudence from Ohio's state constitution and a few other different places, but Ohio plays a really important role. And thinking about that shift between the importance of that comedy we talked about earlier, and instead now we're talking about the importance of trying to get rid of systems that were oppressive, right? The original intent of the 14th Amendment was to start to break down caste and to start to really see how do we ensure a greater equality between folks, and how do we do so by putting further power in the federal government to ensure that states can only go so far. And we see this today at the US Supreme Court and the doctrine of incorporation. And I think that's actually what's so fascinating is this is actually still a process that's playing out. Why did we hang our hat on substantive due process versus privileges or immunities? That is the magic of constitutionalism. That is part of what makes this so fascinating. I can't answer that. I think that, as Chris, you pointed out, different justices may feel differently about this. And they have some probably pretty good arguments on a lot of different sides of this, because there isn't a solid, original public meaning of where this was all supposed to fall, nor is there a solid legal realism to where this is all supposed to fall. But it's really important to be talking about this because this is where we bake in a lot of really important things about what this 250-year-old experiment looks like today.
I have a question about, you raised the issue, Christopher, of text. To me, there's another glaring textual difference between the body of the Constitution, the 14th. In the body of the Constitution, it says in the states.
Mm.
And in the 14th Amendment, it says of the states. Parse
I
that
love
out
that.
for
I
me.
love
The
that.
text. I mean,
So
I
good.
mean, if you're right, the word, there's a big difference between or and. I'm presuming there's going to be a big difference between of and in the states versus of the states.
I completely agree. I completely agree.
So
I
what's the
absolutely-
radical change there then?
I think in many ways you see that movement towards this greater understanding of the union. I think you have to start to think through, you go through this tragic time, the Civil War, and to rebuild the union, to create the more perfect union we want to see. You have this understanding of that devolution that existed pre-14th Amendment, where states still had a lot of powers. That's going to be reimagined once again. The First Amendment isn't going to just be Congress shall pass no law. It's got to be states, you're going to have to follow that now too.
But
And
how
I
does the
think-
word of do that? I guess would be my question.
I think in many ways, the shifts in language that I think you see, not just in the text itself, but I think in the discussions surrounding how we get these texts, you see this greater focus on this more collective action, recognizing that if we don't see this collective action, we're not going to be able to rebuild in the way that I think folks were seeing going forward in this experiment that at that point was not, it was 100 and 100 years old and ish. And I think that it's one of the reasons that it's really important to understand and think through language. It's one of the reasons that I think it's good to think from a textual standpoint. But I always think you have to do that as a legal positivist, recognizing that realism is going to blow right in, and legal realism is going to say privileges or immunities, that sounds nice, great attempt there. We're still throwing it all in under the word liberty and unpack that. And that's something that I think makes this so much more of an interesting journey to see where we've landed in some way, shape, or form.
Sorry, David,
Mike?
I usurped your question rule.
No,
question rule.
what are you talking about? I'm not King Tut here. Well, maybe. Never mind. Anyway, Mike, you were going to say?
Yeah, I just wanted to, I completely agree with Christopher and Tim, and I think the focusing on the preposition is important. But just for the students who maybe are listening and don't have the text out, to me, it's, maybe this is implicit with both of you are saying, it's not the preposition is important, but it's what the preposition is referring to. So in section 2, it's in the several states, and in the 14th Amendment, it's of the United States.
Yeah.
So that I think speaks as well to what Christopher and Tim were just saying about this reimagination of like what that compact looks like. And even that language, I think the students should pay attention to that as well.
Professor Kavanaugh, any insights?
Well, my view from the cheap seats is the of and the in is, I think also one is written in 1787, the other is written in 1866. Mm-hmm. So there is something to take into account there for the students. But I see the reading of the 14th Amendment, right, of the United States as a much more inclusive attempt to incorporate these newly freed people, because we know that's the first part of Section 1. Christopher is referring to John Bingham from Ohio, who we've mentioned several times as the author of Section 1. And I see that of as a much more inclusive. So like no matter where you go, you're a citizen of the United States. So therefore, these privileges or immunities are going to come with you, right? No matter which state you might be in. And I think of the legal shenanigans that will take place once Reconstruction is over. I could almost see people arguing about, well, are they in a state? And if they're in a state, what state are they in? Kind of thing. I don't know, but I think that of is much more inclusive.
Well, let's talk about legal shenanigans then, shall we? My first major professional development outside of the region where I live was in Indiana in 1997. And in this case, the slaughterhouse case, I got slapped down really badly
Kermit Hall.
by
Kermit Hall.
Professor Kermit Hall, who at that time was from the Ohio State University there. So the first major case post-Civil War that dealt with the privileges or immunities clause was the slaughterhouse cases. The general understanding is that the decision in the case eviscerated its application forevermore. All right, that's the general understanding amongst teachers, and it's touched on in a number of textbooks. What did the court rule, Professor Kavanaugh, in the case, and did it undermine, in your opinion, the privileges and immunities clause for the next 150 years?
Last question first. Yes, it did. To quote Akhil Amar, it killed privileges and immunities in its crib, right before it even had a chance to come into play. The case really involves slaughter. And, in a way, you think of the state police powers, safety, health, public morals. You have slaughterhouses in the city of New Orleans, and some of them were upriver from the city. And for the students, if you want to think about what goes on in a slaughterhouse, this is where cattle, hogs, and other livestock are taken to be butchered. And, and this is the 1870s, 1860s, and that's just nasty. And that's getting in the water. That's coming down to New Orleans, right? There's feces, there's blood, you figure the worst Wes Craven movie you've ever seen and then multiply that, right? And so
I haven't had dinner yet there, Chris, so can we move on, please?
Okay, well, a little hyperbole for effect there. But so the city of New Orleans says we're going to build a monopoly of basically one slaughterhouse. If you want to slaughter, livestock in the city, this is where it's going to be. It's going to be downriver from the city. But a lot of butchers said, well, wait a minute, this is a monopoly, and we are going to be out of work. They use the 13th Amendment. They argue that this is enslavement, right? They'll argue due process of the 14th Amendment, and they'll also argue the privileges and immunities clause. So they actually take on three constitutional arguments in this case, and they're over 3 in the case. And Justice Miller writes the opinion, which goes back to something that Christopher alluded to. When did we lose it? I would say with Justice Miller's opinion in Slaughterhouse, because he's not buying this, because his argument is, or his opinion is that, oh, sorry, this only protects certain privileges or immunities, but not this one, right? Your ability to earn money and that idea of liberty that Christopher alluded to earlier, that doesn't really fly here. So no one is going to use the PRI clause after that. And then you get into this Tim's favorite subject, substantive due process, and you get courts say, well, we know there's a problem here. We know that there's an inequality happening, but no one's going to hang their hat on that clause anymore because of that until we get to McDonald versus Chicago. And in McDonald versus Chicago, 2010, this is the individual right for a person to own a firearm. It's the kind of the sister case of DCV Heller. And again, I was alluding to you guys before the program. I was reading Justice Thomas's opinion, and he is hook, line, and sinker buying the privileges and immunities argument. So I think it's there. I think that, and I've said this before, I think we have justices that are reluctant to open that door to privileges or immunities.
Why is that? I don't understand that, because courts in 19th, early 20th, they made decisions based on clauses, and later courts didn't seem to me. I mean, yeah, they may have had discussions and some hesitancy, but not to the degree of this clause.
Well,
I don't understand why this clause or this case, pretty much, tied an anchor to the P&I, clauses. That's for everybody. I just don't get it.
Well, and that's the argument, is that, I mean, even like Amar and some of his writings and other law professors, saying this is unfortunate because the court got it wrong here. The court made a mistake, and the court is so reluctant, it seems like, for years, to say, wait a minute, those guys were wrong, and we need to reintroduce this clause have the substance or the gravitas that it should, because what happens then, people end up going the due process clause or the equal protection clause to hang their hats on, when a much better, I mean, look at all the cases of the Warren Court. Oh my goodness, how many of those cases in the Warren Court were about individual liberties that could have been argued on, you know, the privileges and immunities clause would have been the one to hang your hat on, but they don't go there. So we end up with this idea of substantive due process, which is definitely more nebulous, much more difficult.
And I think you
Go
have to be
ahead.
so practical about that too, right? I mean, let's be realistic and practical. If I am the lawyer arguing a case where this is even an option, am I going to spend my last 2 pages throwing together a P&I argument? Or am I going to spend my time on the last 100 years of jurisprudence where I think I can like get something out of it? And maybe, I mean, I would love to throw my hat in on P&I, because I think that you could probably get somewhere with that, especially at the moment. But there's a practicality, I think, that you have to unpack there. And the practicality is we now have lengthy amounts of jurisprudence on other aspects of constitutional interpretation in the amendment. And if you're not hanging and spending your time there, you could be doing a real disservice to the client, who might be able to win in that particular arena, as opposed to making an argument that, while it's not a bad argument to make necessarily at the moment, still is not, I mean, because you have justices that would probably be very excited. In fact, I think you could have all the justices quite excited, but not everybody would know exactly how to grapple exactly with it. And there's a couple other pieces of the Constitution that are similar, where you see people very nervous to get involved in it, because even just the practicalities of the argument itself.
Are you, Christopher, are you saying that lawyers would craft an argument to appeal to certain justices and maybe?
No, you don't go for that 5th vote. You never go for that 5th vote. You definitely.
And David, back to the point, and Justice Thomas's opinion in McDonald, I'm going to share it with resources so the kids can take a look at it. And it's chock full of stuff for this question, but I would refer you to footnote 15, because time frame 2010.
Wow. Footnote, man.
He must have had a snow day today with a lot of time on his hands.
Well, guys, I've alluded to this footnote before, and I think it's important in the time frame. Christopher, see what kind of little respect I get here. I feel like, I tell you, yeah, my daughter in high school voted most likely to conceive. Anyway,
yeah, okay, you lost your train of thought, gentlemen.
Footnote 15.
Footnote 15.
2010. It was McDonald case. Obergefell has not been decided yet. And if you're talking about privileges or immunities, we're certainly talking about marriage equality. And Thomas, this is Justice Clarence Thomas, right? He alludes to this in footnote 15, that I understand that this could open the door for other rights claims. I'm not making that claim here. I'm making a very narrow argument in terms of gun ownership for Mr. McDonald in Chicago. So I think there's a reluctance to visit the PRI clause because that could open the door for many more rights claims. And I don't think justices are prepared to deal with that.
I have a question. This is out of position of ignorance, which is pretty easy at times. Would it have helped if all these butchers would have been African American? I mean, because arguably the context of the 14th Amendment, a big part of the context is black codes, and the 14th Amendment is addressing narrowly within the context deprivation of rights and equal protection issues for newly freed slaves. So would it have helped if all of these butchers would have been African American? Context matters of the 14th Amendment.
Deer in the headlights here. Deer in the headlights. Okay.
Well,
I don't know.
It probably is a stupid question, but I can't help but think the context of the 14th matters. Newly freed slaves are the direct addressees, so to speak, of the 14th Amendment.
I'm not going to answer that. I do think the context would matter, but I mean, hearing this discussion, there are two things that come to mind. One is that whereas courts can be an institution for social change, most of our history courts have been they've been conserving the status quo of those who already have the privilege and the wealth. And so that's my first, it's up to what 5 justices say, as Christopher referred to. My second point is that I don't know if we could magically get 5 justices to agree that the privileges or immunities clause meant something. I think we're in the same mess as we're in with the substantive due process.
Oh, sure. Yeah.
I think we've mentioned this on previous programs, and I'm getting more and more frustrated with this. Why don't we just say what we think a human being on any planet, any country on Earth, or any planet in the universe, right? Why don't we look to the Universal Declaration of Human Rights? Like, that lays out specific rights and privileges and immunities that we as human beings should be able to have. And it's frustrating because while, Chris, I agree with you, I would read the privileges or immunities clause to include marriage. That's just based on what I wanted to read, right? And I think we're just kind of getting into the same, trying to fill that space with whatever we think it should be in there. And I just wish that I wish the drafters of the Constitution and the 14th Amendment were more specific about what they thought needed to be specifically protected, because we're not. And other constitutions in the 1990s have done this. And I think it's been better for how their democracies work, because citizens know you can make specific arguments. You're not guessing. You can make a specific argument that you have a right to shelter, and you go make it, right? And then you let the justices decide on the merits of that. So
Christopher's been smiling and gnawing at the bit there.
I think, Mike, I mean, you make an incredible point. Let's just take, I love comparative constitutionalism. So let's take a place like South Africa, where they wrote the longest constitution. Everything is, enumerated in 120, 30 pages or whatever it is. But then they have the opposite problem, which that now, we sort of attempted to figure out with the 9th Amendment. That's a whole nother show, folks. But something that we, tried to figure out there, where they face this constitutional issue where if it's not actually written, courts always, not always, but frequently say, you really wrote it all down. So if it's not in here, you got to fix that. And I think in some ways, that's one of the magical balances that exists in our society. And what I mean by that is this. We're talking obviously on the federal level, as we should be. We're talking about the 14th Amendment. We're talking about Article 4. One of the great balances in our society is the fact that we have this incredible federal system where states have the opportunity to, outside of not that many things, actually be laboratories within their state constitutions, and to go beyond what the federal constitution requires, and to do some really incredible things with that. I can just speak for New York for the moment. And we have this incredible part of our state constitution that ensures that the Adirondack Park is forever wild and you can't build there. And it's in the state constitution. It's been litigated up and down, and there's literally like 2 people who even know what that means. But those 2 people keep winning their cases. And that's an incredible aspect of New York that I think is fascinating, because we do have those opportunities and abilities. One of the things, somebody brought up marriage equality, that I find fascinating about the history of that movement. It was much more difficult for equality to come on the marriage bit. Wasn't that hard for divorce equality to come, because states kept affording comity to divorces from other states, where they did not afford marriage from marriages from other states. And I find that to be so interesting when you think about the history of how this actually works, where you have judges that wrote opinions that said there's no marriage equality in our state constitution, but I gotta let you get divorced because comedy. And there's lots of different cases of that if you actually look historically across the country. That's part of the beauty of this laboratory that we're all talking about. It's also part of what can make it very frustrating. And I get that as students, because it's the complication that can both say, well, it works here, it doesn't work here. Well, yes, but in part, that's, I think, Mike, why we all are such fascinated as students ourselves of how this all comes together. And I think that's part of what makes this such an incredible exercise, an important exercise in ensuring that we're all dutiful members of this society working towards that more perfect union I mentioned before.
Dave, can I push back on Professor Williams for a second?
Briefly.
Regardless of what nation we're on or what planet. Part of the issue, I think, David, with our courts has been this struggle to expand the us and reduce the other. And because it's been such a struggle, right? And so we've nitpicked, we've created categories for rights, and we parse them out based upon, you know, this legal theory of, say, substantive due process or procedural due process. And are you entitled to them? Let's think about this. Or is this a civil right? Is this a political right? And so we instead of just saying, you know what, we understand this basic fairness of how law should be interpreted to include all people. And yet it's been such a struggle because of our reluctance to expand the us and reduce the other. And if it would have been much easier had perhaps, you know, our courts not have the power that they do. And you know, we're talking about comparative constitutionalism. We've talked about this before, the power of courts in other countries to expand rights. And they do it, I would say, maybe more wholeheartedly than we have. And we just kind of pick around the edges because we're worried about certain groups of people getting certain rights or privileges or immunities. I think that is a frustration, the idea that we're going to put a right in a category and decide whether or not, you know, you have this right.
Well, kids, this is probably going to be a little longer segment because Professor Moore's about ready to come out of his panties here. So, Professor Moore.
There's a text, Chris. The text says, it doesn't say us and others. It uses words like citizen, people. I mean, the text does matter somewhat. And privilege and immunity says citizen, and then people get the other two things. So I'm
disagreeing with that.
That's a textual problem at a minimum. And I'm willing to suggest that also is a massive legal project to parse out and I actually agree with you that your analysis of us and them and inclusion, I agree with that. But unfortunately, the Constitution doesn't use that language. And so therefore, I guess I'm making an argument we have to live with being frustrated.
Well, but I don't think we should. But I'm gonna push back because, yeah, I agree. There's a difference between privileges or immunities of citizenship and due process and equal protection for all persons, because it says all persons. Right. And Bingham actually talks about this in the need for this whole idea. I mean, the whole notion of think about the whole notion of selective incorporation. The authors of this thought the Bill of Rights would automatically apply to protect all people against states. And it doesn't happen because why? The courts. And this is out of the Corfield massacre and then Cruikshank and the stuff we've alluded to on prior things. And so we piecemeal it out. And if I'm a Black citizen, I'm a citizen, because that first part of the 14th Amendment says I'm a citizen. So why am I having to figure out, well, this right fits in this category, whether or not you're going to get it?
Because the text doesn't say it's there.
It says,
unfortunately.
Okay, we cannot solve this tonight, and we've got to move on. And given that the word "others" has been used, let's move to immigration. Always an easy topic to discuss with simple answers. Professor Williams, American immigration policy, in my opinion, has been a historic roller coaster ride, depending on conditions, circumstances in certain periods of our history. And I would argue that we are in a period of contraction, kind of a anti-close the doors, build a wall period when it comes to immigration policy. Do you agree with me on that? And how do you explain in the 21st century that we're in a contraction?
Yeah, this is going to be super easy. Let's go.
I like it when I ask easy questions.
Yeah. Okay. I haven't seen the most recent public opinion surveys, but I would agree with you that there is there's been a growing perception, I would argue, since the turn of the century, about being more nativistic, right? Nativist, more fearful, sometimes not based on the evidence, that those coming from other countries are going to either take our jobs or commit crimes or somehow do harm. So I agree that that perception is out there. I do think the way you framed your question was about our policy, and I think it's important to point out to the students that, as the students should know, the Congress is in charge of making our immigration policy. They can delegate to the president some of those functions, but they have the say on this. Our current immigration policy provides legal avenues for how people can become either permanent or temporary workers. The permanent workers we refer to as getting a green card, and temporary workers are like for students or temporary workers to come over. We have limits on the numbers of people who we allow in this through this permanent and through this permanent legal structure. Those numbers were set in 1990, and they have not been changed. And our economy has grown almost double since then. So we have a immigration policy crisis right now. We have more jobs available than we have workable, employable citizens and immigrants in the country right now. There are many businesses and many policymakers who are clamoring for an increase in the number of visas to meet this need. And that's what other countries have done. For example, Germany and Canada and others are in a process of like extending these types of visas, both temporary and permanent, to get workers in. But I think fueling this, what you say, this idea of closing up the borders, I think is, I did some research on this just before we got going on this. We are now, as a country, have about 47.9 million foreign-born residents, and that includes both legal and undocumented. We've seen an increase of about 2.9 million since January 2021, when President Biden took over. We are about to reach a percentage of foreign-born people in the country that will surpass our high of 1910. So this is not a perception that there are more foreign-born people here. That's a reality. Now, the reaction to that amongst people living here and politicians, I think that's what you're getting at your question. But we're actually at a period where there is a need for more immigration, and our policy has set it where it's closed off. The waiting periods to get visas and the waiting periods even to get family members into the United States is sometimes 7 to 12 years. So with that reality and with the crisis happening in our hemisphere in terms of the violence happening, there has been a real push of people trying to get to safer places. So I know I'm just giving like the high point bullet points, but I do think that there's something real is going on, and our policy for decades has not matched what the reality on the ground is.
Well, go ahead, keep going.
Well, and then the final thing I just want to say, because I think it gets to this privileges versus immunities that we didn't resolve, but I just want to point this out to the students, that in our law right now, if you are a citizen of the United States, and if your spouse is foreign-born, or if you have unmarried children under the age of 21 who are foreign-born, or there is no restriction on how many of those people can come to the United States. We set no limit, right? Versus if you are someone who is a green card holder, right? So you're holding a green card, you're here legally, and you want your spouse or children to come over, we set a limit of 114,000 per year. Which means that there's this huge waiting period for the spouse of someone who is a permanent resident here with a green card. So I think that, I don't know, it's not going to resolve the thing, but there's definitely a privilege of being a US citizen. There's a privilege in terms of getting your family members to the United States in terms of the numerical limit versus being a non-citizen, but being here legally and having a green card. And I think, I don't know, that's something for students to think about as you're thinking about privileges and immunities, citizens versus people, as Tim and Chris and Christopher were just talking about.
Well, I know this is a policy question, and we generally are uncomfortable with policy questions. And so I want to keep going with this.
Ask Christopher then.
Yeah. Well, no, I know Professor Kavanaugh, myself, we like policy. It's just that for students, it's okay. We don't know. I mean, this is an inside opinion kind of stuff, and run with it as you may. So there's a consensus in America among scholars, experts in the field, and I think general lay people, that the immigration system has been broken, and it's been broken a long time. This is to all of you. Do you all agree with that the system itself, the structure of immigration policy is broken? What's the source, if it is indeed broken, what's the source of that break? And what recommendation would you make to bring sanity to the system? And so, Professor Ayano, we want to start with you, because New York, like California, is a pretty good magnet for the immigrant population, and we've both done pretty well with it, to be quite honest. There, so I'm curious about your thoughts.
I think in many ways, I have to even come back to my own family's journey, right? I mean, my great grandparents came through Ellis Island and had their name changed because they couldn't pronounce their name correctly. My grandfather came over on the United States, the boat, and that's now in Philadelphia, decaying because it's so old. I'm a product of immigration, and I take that as something into any conversation about this as something that's really important, because I think you can't divorce yourself from the reality that informs your own experiences in this country. But I think that's actually one of the things that makes this so fascinating and also so critical, is that we are a nation in so many ways that has a number of folks who've come from lots of different places, and in so many ways, I think, New York, California, but in the bigger picture, we've have this multi-100, 200-year-old experiment that includes and attempts to be more inclusive of everybody that's here. And we certainly have not done a great and a perfect job at that. There are many instances in our history where we've done a pretty lousy job when it comes to this topic. There are other times in our history we've done a much better job when it comes to this topic, but it actually ties to something, and I would remove just immigration itself from this question, and I would actually go to a larger picture answer, which is, well, any policy issue that's not being addressed, and any policy issue that's not really getting the attention it might deserve, may not be being addressed and may not be getting the attention it deserves, because maybe there are other issues that are happening when it comes to the actual impact that bodies like Congress are having in the way that our system of government functions at the moment. And I think I'm pretty confident in saying that the way that Article 1 looks at the moment at the federal level is certainly not the way that the framers looked at it and thought it would operate. It certainly is not the way that it's operated for much of the history of this country. And I think in many ways, you can actually find a lot of consensus about where decisions are made and how that looks at any governmental level. At the end of the day, power will reside somewhere. Somebody's got to make decisions if things are going to function. And if that's not going to be Congress, it's going to be the executive. And if it's not the executive, it's going to be the courts. And if it's not the courts, it's going to be the bureaucracy. And if it's not the bureaucracy, it's going to be the states. And if it's not the states, it's going to be your local representatives. And I can go on and on and on. Decisions will be made. They have to be made for government to function, for society to function. So I think on any topic of this importance, where decisions are not being made, where there are issues in seeing and making consensus at a level that it should be made at, right? This is something that really should be thought about on a national scope. where you see that failure happening, you see people get frustrated by that. You see people attempting to find ways to fix that. But historically, again, we've done this well at certain points, not so well. We never do anything really perfectly. But this is actually a really good example of just the importance of thinking about how democracies function, majority rules versus minority rights, the great scale that exists in any constitutional democratic republic, and where you put those decisions and where they reside and who gets to make them. And I think in many ways, it's the responsibility of all of us to be participatory, not just a week ago when we all voted, but today in our communities and in our societies to make sure that these institutions do function, because we participate and we make ourselves heard and we find ways to make things better at whatever level of government that we decide we want to, or within our civil societies as we decide we want to, because that's actually something that's very quintessentially American. And I think that helps to break some of those log jams down when people are engaged, not just in the voting booth, but 365 days a year. That was a really big answer.
I can't help but think historically, I mean, to your analogy that immigrations, there's this ebb and flow. Americans have never been very astute at reading world events. And I think like in the 1790s, we were scared to death of all kinds of French immigrants. In the 1830s, 40s, Irish Catholics. Gilded Age, we're afraid of Jews and Slavic peoples. Post World War I, we're scared to death of Russians and communists. I think Americans just don't understand world events and why, and those world events come to our shores. And there's this perception that, south of the Rio Grande, everything's broken and busted. And in many cases it is. So I think that the ebb and flow reference, or the roller coaster in your question, David, is many cases a perceptual issue of Americans not really understanding world events and why these world events come to our shore. And these nativist moments, this xenophobia moments that we have, I think are in part because we don't understand world events and why they're here at our shores.
Professor Williams, Kavanaugh?
Well, I think that, Christopher is way too polite. I'll lay this at Congress's. They have a constitutional authority, Article 1, Section 8, Paragraph 4. They have the constitutional authority to deal with this. And when they don't, nature abhors a vacuum. And when they don't use their power, everybody in this modern age, they look to the executive to solve it, right? And I think that is a problem. And so I would say it's because Congress is a little more feckless. They are not using their authority for whatever reason to work through this mess. And Tim is absolutely right. Historically, I've used a lot of turn of the century cartoons dealing with immigration, and what's passed as prologue. There's a great cartoon of a wall that's built, right? And a businessman is holding a ladder, allowing these foreign-born workers to come over. And there's an American businessman complaining to Uncle Sam as these people from outside the wall come in. There's a character drawn, I get into the racism of it, busting through the wall with a knife in his mouth. And my students think the guy's Hispanic. He's not, he's Italian. And it's the stiletto is the knife, right? It's an Italian knife. And so the kids see this and they, oh, well, this is a guy south of the border coming in to take an American's job. And this is actually an Italian from the turn of the century. So it is nothing new. We struggle with this from the jump because of the fear, as John Jay said, put a ring of brass around New York City. Ben Franklin worried about the Germans taking over Pennsylvania. So this is something we've struggled with. And to Tim's point about modern events, I was just listening to Nerd People Radio on the way home. That's NPR students. And they're talked about climate change, refugee crisis, and and this growing nativism that exists now, and they're all at this crossroads because of what you're starting to see are people, especially in different parts of the world, trying to get into Europe. And you see within the European Union, folks not able to come together, obviously with a new government elected in Italy, very much opposed to this. And Italy and France are butting heads about letting people in. And this is, my alarmist kind of viewpoint was, we better figure out how to deal with this, because it is not going away, and it's only going to get worse as the climate continues to change and people are trying to leave places that no longer have water. They're going to come to a place with water. We need to figure it out. And I would lay the blame at Congress, and that's why.
Mike?
Yeah, I kind of want to add on to what Christopher said, and I think that democracies are susceptible to these types of us versus them arguments, and it gives the people the ability with free and fair elections to put people in power who will, put those ideas into policy. And I think that, so I think we're susceptible to it. And I think that, again, drawing on Tim's point, I don't think we realize that other countries in the world know this about democracies. I just read this fascinating book by Timothy Snyder about Russia, the Ukraine, the United States. He wrote it in like 2017, right when President Trump was getting
Is this
elected.
on tyranny?
No, this is his other one. I'm forgetting the name of it. But his point is that Putin in 2013 and 2014, when he was decided to use his military power to basically save Assad in Syria, part of the inner discussions with Putin with his advisors is that I want to create a refugee crisis because I know that that is going to cause a change in politics in Western Europe, because these are so-called open societies. So let's see them deal with these refugees coming to their countries. I mean, he has documentation that this was part of his, not the reason, but it was part of it. And it just, as I read that, I thought, oh my gosh, like in some ways, President Putin maybe kind of understands the pulse of democracy better than a lot of Americans do, right? How democracies can be susceptible to that kind of foreign policy. So I'm just kind of adding on to what Christopher and Tim were saying earlier.
Well, when Christopher was speaking, I thought he was channeling you, and when he focused on the notion of power. I do have a quick follow-up. I'm curious, because the kids are asked, again, a pretty policy-based question about assistance to immigrants. And I'm wondering, does the 14th Amendment provide any guidance as far as assistance to immigrants, whether it's the equal protection, due process, or privileges, well, not privileged immunities, because P&I only applies to citizens. So I just wondered, if I'm an immigrant and I want some, can I go to the government and say the equal protection clause or due process clause mandates that you provide me some assistance? Professor Riano, am I way off base out there in la la land?
Well, I think that in many ways, what I think you see historically is that different states look at that different ways, different localities look at it different ways, and certainly the federal government looks at that different ways. And I think that because there isn't a uniform way of looking at that, pointing at the US Constitution has not been very fruitful in the big scheme of things, because it just hasn't been a place that folks really can hang their constitutional arguments when they don't necessarily have the standing that courts may be looking for. But I think that doesn't necessarily change what I said earlier, which is that in certain localities, in certain states, there are different ways that people look at that. And that's part of, again, the beauty of our federal model. Not everything is the same everywhere. People can experiment and try new things depending on where you are. And that is actually the very definition of local democracy, right? And local democracy, the idea that in New England, we actually still have democracy, like people get together in places and actually just vote on things, which is incredible when you think about that, because that's basically found there in like Switzerland. I mean, it's awesome that they still do that. And thinking about that again, majority rule, minority rights balance, how that looks and how that kind of all functions, and how it is a marble cake is part of what makes this so interesting. So I always tell students when I have a chance to talk about, well, how this, not just on this topic, but just more generally operates. It's good in many ways to have certain federal floors, but it's also really good that there's a lot of different ways that different places approach this, because this is a very heterogeneous society. And as we go from 330 million to 350 million to 400 million, and we have lots and lots of different ideas and backgrounds and thoughts, it's good that that flexibility exists in the system so that different things can be tried out in different places and different opportunities can exist for folks in the places that they decide to call home.
So you come across as a lover of federalism, and just so you know, federalism is one of the F words amongst the friends of Publius here, and students are asked to deal with the question of state citizenship, and I'm going to be upfront with you. It is my opinion that whereas you say that states are the laboratories of democracy, I think they're also the laboratories of repression there. So I've got to ask you, and the reason I say that is because I think there's just way too much democracy, or way too much, I don't know if democracy is the right, but way too much choice in our system, in the federal system there. And I looked at this regarding this last election. I had 36 different things I had to vote on. All right. Not only do I have to do that every 2 years, which to my knowledge, and maybe you and the others can check me on this, we have more frequent elections than any other country in the world in our federal system. All right. Every 2 years. And then you have then you have states that do it, in the off years. And we elect sheriffs, for crying out loud. We elected judges. In my area, we elect water district officials. We elect dog catchers. We elect so many things that no wonder voter participation is down, because people are just burned out. And plus, how am I supposed to know which judge or which candidate for sheriff is more qualified, kind of stuff? So I'm wondering your whole general feeling about the democratic system and federalism. Do you think we've gone overboard with this democratic notion?
I think in many ways, something that you've brought up is actually incredibly part of what makes this all brilliant. I mean, there are parts of New York where people vote for their coroner. So if you can describe how one coroner is more qualified than another coroner.
And how would you know that? How would you know that
election? I would love to know. I'd love to see the treasurer for this guy versus this woman. I mean, go for it, right? I think you've hit the nail on the head in something, Dave, where in many ways, maybe in certain states, there are too many things on the ballot, and maybe in other states, there's not enough. I certainly know that we vote every year here in New York for something or another, because I feel like I'm always voting. But isn't that my decision that I made when I voted for my state representatives, to make it so that I could vote for all those folks? Because that's where I let general police powers reside to make that decision. If I don't want to vote for judges anymore, don't I elect the folks that get to put that in the constitutional ballot in New York? Because we vote for our judges too, which I've never quite understood. And that's something that I get to make that choice, because I can go and not just vote for my representatives, but also lobby them to make that change. And so if I really didn't like that, having been born in Ohio, I'm very proud to have been born in Ohio, and promptly left and moved to Maryland, which is very, very different, and then moved to here in New York, which is totally different. Isn't that actually part of the privileges and immunities that I have under Article 4 to turn it all the way back around to?
Oh man, that's good. That was
and
good.
Make decisions about
good.
where I want to live in the United States and get to make that choice. So, Dave, I am the first that will tell you, if you're voting for too many things and there's too much democracy where you are, pack up, and you can use the 4th article to go wherever you want in these great 50 states.
We have
and
water,
that actually
Dave.
is part of what I think is so wonderful. And if it's really the water district that causes that, maybe that is too much democracy for some folks. Maybe it is. The judges I get, the water district chief, a coroner, certainly. That's a reason to move. That is definitely a reason to move.
Okay, touche on at least the last part of it. I guess I could move to North Dakota or somewhere. Gentlemen, the rest of you, any thoughts on that? Or are you all just, he just shut you all down?
Yeah, we're perfectly willing to have him beat you about the head.
Well, I think part of it is that you end up voting on so many resolutions in California ballot measures is because you have a lazy legislature.
Oh, so this becomes a bash on California moment. Okay.
Yes, because you don't do referendums initiatives right. You should do them like Wisconsin. They're not as loosey-goosey as they are in California.
Okay, I'll channel my Hiram Johnson, and you can, talk to
Well,
him.
I mean,
on that
let's
kind of
face it,
thing.
when you guys are voting on whether or not male porn stars are required to use condoms and you guys get to vote on that, is that too much democracy?
Wait, how did I become the lone minority voice on this?
You brought
We
this up.
talked about this.
Sir, you
multiple
introduced
times.
it. You introduced it into the discussion.
Well, yeah, but I also have a recorded, I have a record, here of the number of times where you've, never mind. I'm going off. Professor Iana, that was a great retort to my position. I'm not a fan. I don't see the beloved wonderfulness of diversity in the nation when it comes to rights in this country, because you're subject to geography then, that is our history has proven. If you're gay, lesbian, transgender, or even persons of color, you're subject to the laws of localities there, and hoping that the federal government sometimes gets involved if they have the political, as you say, willpower to do so. So we unfortunately, and time is always our enemy here, we have to bring this to a close. And our tradition is to give insights and recommendations to students and teachers as they approach this question. So Professor Williams, your thoughts on Unit 6, Question 1.
Yeah, I kind of think this is a difficult challenge for students, because I see there are really three separate questions here. I mean, so I think it takes a radical turn from P&I to states citizenship, then to immigration. So my first suggestion is, if you can be the team that does just what Christopher did and find a way to weave those together, then more power to you. I think that would be really powerful. My other suggestion is more on a micro level. The final bullet point is about assistance to immigrants. And if I were a judge, I would think, what do we mean? Like, immigrants is a huge group of people. And the most vulnerable of the immigrants are those who are asylum seekers or refugees. And so, I don't know, I would think that you'd want to think through which subgroup of immigrants do you really want to focus on? Do you want to learn about what assistance is currently given, and then provide your opinion on whether that assistance is adequate or not? So, because I think dealing with all immigrants is just going to be too much, maybe, to get into a question or into an answer. Sorry, that's what I got.
Professor Kavanaugh.
I would agree, because we talked about that earlier about parsing out, when we were talking about the language earlier, and now you're talking about just immigrants, and there are so many different people that come to our shores for so many different reasons. And so I think it's important for the students grappling with this question to think about how you want to approach that, and obviously be prepared in your follow-up to dive a little deeper into that, because obviously, you've got a 4-minute response. A third of that will be dealing with the last bullet. So be prepared for those nuances in types of immigrants that Mike just alluded to, right? I would also say this is a place, the first question is a place about passion. I think where we can talk about, where we're finally starting to talk about liberty and equality in the Constitution that we find in the 14th Amendment, and the struggle that has been for so many people that have been outside the law to be inside the law now. I think that's provides for a great deal of passion, and this is a great place for a great question for it to come out. I I think know what happens within your state, right? As Christopher alluded to, these laboratories, know what happens specifically in your state, know what your state constitution says, and perhaps know what a couple different state constitutions say in terms of this idea of privilege or immunities, or even, immigration. One of the questions I always ask my students, is the Rio Grande, is that the border of Texas or is that the border of the United States? If I travel a couple hours north of where I'm right now, is that the border of North Dakota? Is that the border of the United States? Which is it? And think about how you would grapple with that type of question, as in terms of every state is going to be a little bit different. So know what happens in your state.
Professor Moore.
Yeah, I'd like to maybe extend Mike's thinking on that third bullet. One of the questions in that third bullet is something to the effect that what kind of assistance should be provided. And I guess I'm gonna channel my inner Mike Williams here. Do some comparative work here. What does Germany do? What does Sweden do? What does Kenya do? What does? And I think, honestly, I think students will be well served to think about what other places do with immigrant populations coming in. What kinds of assistance do they do? I think you'll find some interesting ideas that maybe that the United States could do. So, because there's also a normative question, that where you've got to make a judgment call of whether this is good or bad or not. So do some comparative work before you run right to your conclusion. So look at other places is what I would say.
Just Professor Rayano.
I think in many ways, one of the things I always come back to when it comes to thinking about any questions and just in general, the way that the competition operates is I think it's always a good idea to not shy away from the hard stuff. I think that it's okay. I think it's actually quite virtuous to have the conversations about the hard things. And when we're talking about a clause in the Constitution, 2 clauses actually, that are separated by over 100 years of where they're put in and what they may or may not mean, and then talking about one of the most complex policy questions that has ever existed in our national experience, it's good that we're having conversations about the hard stuff. It's okay to take positions on hard things. I like what Tim says. One of my favorite courses I ever taught is comparative constitutional theory, because I think it's so important to think about the way that different people operate and different systems operate. I think it's a good thing, Dave, that you vote for Water District and that I don't, because I wouldn't even know where to start. And I think that that's okay, whether it's within our 50-state system or outside of our 50-state system. I always find it fascinating to talk about, in Germany, how they have a constitutional court that an individual can petition for constitutional rights. No concept of that here. Well, what does that do? How does that have an impact? What would that look like? Those types of really complicated questions are exactly what this entire process is designed to do. It's designed to give people the tools to ask difficult questions, to have difficult conversations about things that people disagree about, and still come away with it with a baseline understanding of where we've come from, where we've done well, where we've done poorly, and yet how to make things better going forward. And so I think in many, many ways, threading all of that together is exactly the goal that I think every teacher, every coach, every scholar, and every judge has in mind when it comes to the competition. And I think that's always what I encourage students to come into this thinking in the big picture.
Well, students and teachers, I believe you've got a lot of material to work with from this session. It's been lively, it's been vastly enjoyable, and I hope we get a chance to have Christopher Rayano, the CEO of the Center for Civic Ed, back again. I think the greatest tribute I can give you, Christopher, is that I'm a lifelong student. I'd love to be in your class. If you taught constitutional law, you're dynamic, charismatic, and God, smart as hell. Which surprised me because you're from Ohio. Anyhow, next week we're going to be talking about the executive branch, the presidency, and the different ideas about the presidency. Until then, peace, love, you ever tacos? Bye-bye, bye bonds.